Good morning and welcome to another presentation brought to you by Global Solutions. In this presentation we're going to deal with what is known as tort damages. Many people are involved with various governments and or other companies or individuals, and they conduct themselves in a way which is inappropriate or subject to what could be a tort damage claim. Many people have asked me what I can do about council tax or the local municipality or other government organizations, and I tell them that you may want to look down the avenue of tort damages. Many people do not know what a tort damage is. Therefore, this presentation, which is about 30 slides in length, will explain some of your potential tort damage claims. Anybody wishing to go down this road is also advised to investigate possible other tort damage claims. I will be doing a separate presentation that deals specifically with how to proceed or start an action in a court. That will be coming very, very shortly. Without further ado, I will continue. Before I do continue, however, I must advise the reader and or viewer that this is not legal advice, and it is up to you and your responsibility to ensure that what is presented here is current, up to date, and that you apply the information correctly and or appropriately to your specific situation. Every situation is slightly different and may involve slight differences in the way you present the file or present the case, and or what information is required to substantiate your claim. Torts are defined by various explanations or various subtitles. We have defamation, battery, conversion, invasion of privacy, trespass, nuisance, pain and suffering, negligence, trespass to land, malicious prosecution, product liability, assault, false imprisonment, strict liability, various liability, medical malpractice, economic torts, number of things, breach of duty, breach of public trust. I am going to go through on a slide-by-slide basis and explain many of these potential claims that you could use. Assault is a common law charge, as is all the rest of these tort damages. All tort damages fall under common law and or also under statutory law. Common law assault is a tort of acting intentionally with either general or specific intent to cause reasonable apprehension of an immediate harmful or offensive contact. Assault requires intent. It is considered an intentional tort as opposed to a tort of negligence. Assault does not have to be physical assault. It could be assault of your mind, assault of your body, assault of your soul, and or some other unwanted assault such as sexual assault. So if you are being exposed to an RF signal from a smart meter, you could consider that as an assault because it's an unwanted action. If you are being tormented from the local municipality and they are operating well outside their jurisdiction, you could consider that an assault, because an assault is a tort of acting intentionally with either general or specific intent to cause reasonable apprehension of immediate harmful or offensive contact. But when you're being harassed by the municipality, I would argue that that is offensive contact, which you did not want. You can do further research and look into other forms of assault and or potential assault charges that are directly or indirectly related with an assault. For the purpose of this presentation, I do not go into great detail because we could be here for several hours. The next common law charge is battery. Battery is a tort falling under an umbrella term, trespass to the person, entailing unlawful contact, which is directly or intentionally, recklessly, or in Australia negligently and or voluntarily bringing about harmful or offensive contact with a person or to something closely associated with them, such as a bag or purse, without legal consent. So you've heard of assault and battery, right? Assault was our first charge. Now, assault and battery, they could maybe try to steal your purse or your bag, and maybe they punch you or hit you in order to obtain the item in question. That would be assault and battery. If you notice here, this is a common law charge, as was the last one. This also falls under a criminal charge. Then there's breach of confidence. This is a tort. Breach of confidence is another common law tort that protects private information that is conveyed in confidence. A claim of breach of confidence typically requires the information to be of confidential nature, which was communicated in confidence and was disclosed to the detriment of the claimant. Now, in such a case, DVLA in the UK discloses your private information regarding your address, potentially your phone number, your license plate number, maybe your place of work, related to a parking infraction or a case in magistrate's court. And then they disclose it to, let's say, the private bailiff, who then comes to your property attempting to confiscate your car. This information should be protected under the privacy of information. The only time the DVLA is permitted to disclose your information is when there's a criminal case, such as you were involved in a hit and run or a convenience store robbery, something of that nature. Therefore, anybody being harassed by local counsel would theoretically or technically have a claim against DVLA and or the counsel for disclosing your private information to a bailiff. Now we have breach of duty. There can be no liability in negligence unless the claimant established that he or she was owed a duty of care by the defendant and that there's been a breach of that duty. So in the case of a court hearing or dealings with the counsel, they're supposed to keep your information private, and they also have a duty to ensure that what they're doing is being done lawfully and in accordance with the prescribed legislation and or regulation. In the case of council tax, as far as I've seen, they breach their duty because they are not ensuring that what they're doing is actually lawful. I have a book which is in the works which deals with all of the violations, or at least all the ones I'm aware of, related to council tax. As such, you could use that book and or this presentation to establish a lawful case against the local municipality, the local court, and or the bailiffs who are harassing you for council tax. I have 3 separate videos that deal specifically with council tax, another one that deals with private bailiffs, and one that deals with the paperwork that comes with your so-called council tax liability. All of the mistakes that are outlined in that, or those documents, are in fact a breach of duty by also the court as well as the local council. Then there's a conversion is an intentional tort, right, consisting of taking with the intent of exercising over the chattel in ownership inconsistent with the real owner's rights of possession. In England and Wales, it is a tort of strict liability. Its equivalents in criminal law include larceny or theft and criminal conversion. In those jurisdictions, that's recognized as criminal conversion and is a lesser crime than theft or larceny. So when they attempt to steal your vehicle for the non-payment of council tax, that in fact is a conversion. They're intending to steal, which is theft, which is criminal. And then they want to convert the proceeds of the sale of the vehicle and or other stolen property to something in order to cover the alleged debt from council tax. Also, when you are charged with a parking infraction. The parking authority is attempting to extract money from you, and if you don't pay the potential bill, then in some cases they will hire bailiffs to steal your vehicle and then try to sell your vehicle to recover the costs. Each case in conversion is a separate case or a separate claim and has specific points or merits to that claim. This is just a general overview. Now we have conspiracy. This is a civil claim. Generally, it could be criminal. It's an agreement between two or more parties to deprive a third party of the legal rights or deceives a third party to obtain an illegal right. So in this case, when you have council tax working with the local magistrate's court, that's two parties, right? The court's one party, municipality or council is the other party. They're working against you. In fact, it's been admitted on record that the court works on behalf of the council. Well, there's two parties right there, and then they enlist the services of the legal advisor. And in some cases, when a council tax hearing has been appealed, the higher court, in this case the administrative court in Manchester, has actually agreed, the judge agreed, that he was going to rely on the defendant to help him present the case. Well, that's now a third party involved in this, which is another conspiracy to deprive the rights of the third party, and the third party in this case is you. So they're trying to deceive you, and you're thinking you're going to a court in order to get a fair trial, and the conduct is already, as outlined here, has already proven that that's not possible and not going to happen, which makes the entire court case and the initial hearing with your magistrate's court null and void from the beginning, or as we say in legal land, ab initio. Now we have another one, which is a common law, again, charge under contributory negligence. This is a defense to a tort, a claim based on negligence, if it is available. The defense completely bars the plaintiffs from any recovery if they contribute to their own injury through their own negligence. Now this is a good thing, because in this case, related to, say, council tax, they operate completely outside their legal authority. Their court cases are conducted privately, with no court file number, nothing on the registry. It's generally done in private. It's generally done contrary to the Magistrate Court Rules, Magistrates Court Act, Senior Courts Act, Civil Court Procedures. It's done without a notice before claim or letter before claim, and as such, they should not be entitled from recovering their costs, right? The defense completely bars the plaintiff, which in this case is council, or the city council, from any recovery if they contribute to their own injury through their own negligence. And I would state that this claim presented here could be used in a defense against council tax. And when they bring you in there, they're the plaintiff in the initial claim, and you're the defendant, so this would be applicable to a council tax hearing at its initial stages, when they first bring you into the so-called hearing. Then we have defamation. Defamation, at a first approximation, is any form of communication that can injure a third party's reputation. This can include all modes of human understandable communications: gestures, images, signs, and words. This is particularly noted in Canada, specifically within the province of Ontario, related to doctors. Many times they have a hearing, which is conducted in Toronto, and the doctor has already been pronounced guilty in the newspaper, on the radio, maybe on the television, before they've even presented a hearing. This is a defamation of character, right? And any communications, now even though the communications happen through radio or television or the newspaper, it's still a form of communications and was released by, in that case, the College of Physicians and Surgeons of Ontario. A similar thing would happen if your name was broadcast to the newspaper and you were supposedly guilty of a crime before you ever had a trial. Irregardless of the nature and or cause, you should not be pronounced guilty or slandered in any way, shape, or form until you have actually had a trial, which was conducted in accordance with the civil court procedures and or court rules. And if you are subject to this, this would be a potential claim you could put against the offender, whoever they might be, probably some general government organization. Now we have economic torts. An economic tort, which is also called business torts, are torts that provide the common law rules on liability which arise out of business transactions such as interference with economic or business relationships and are likely to involve pure economic loss. So if you are involved in council tax hearing and they do something which causes you a economic loss as a result of your employment, you have a contractual agreement with your employer. Or if you are in your self-employed and you have a business, the same thing would apply. Okay? Everything that you do is some form of business, even if you're not working for yourself. If you are hired by a company or employed by a company and some government agent comes along and causes you economic business loss because you're involved in a court hearing, for example, you could use this economic torts claim in your case against them. Then we have false imprisonment or unlawful imprisonment. Occurs when a person intentionally restricts another person's movement within an area without legal authority justification or the restrained person's permission. Actual physical restraint is not necessary for false imprisonment to occur. A false imprisonment claim may be made based upon private acts or upon wrongful government detention. So if you're pulled over on the side of the road for some alleged traffic offense, you may have a potential claim against that officer or police department. The other thing is, if you're not permitted to attend a court hearing, that's also false imprisonment, even though you haven't been actually jailed. So there's a number of cases where this would apply to government individuals. The other thing you can have is an intrusion on seclusion, which sounds kind of funny. Intrusion on seclusion is one of the 4 privacy torts created under U.S. common law. Intrusion on seclusion is commonly through the bread and butter claim for invasion of privacy. Seclusion is defined as a state of being private and away from people. So if you're secluded and or prevented from going into court, you may use that claim against the government and or the court. Then there's the intentional infliction of emotional distress, okay, sometimes called the tort of outrage, is another common law tort that allows an individual to recover for severe emotional distress caused by another individual who intentionally or recklessly inflicted emotional distress by behaving in an extreme and outrageous way. Some courts have sustained mental and or emotional damage, but the tort is the same. So you may run this situation where you're involved in a hearing where the prosecutor for the opposite side tries to do something to cause you emotional distress, such as calling you a free man on the land or opto-pseudo-litigant, and a lot of times they do what's called an attack on the person, and instead of addressing the actual points which are related to the case. Generally this is done if they have no defense. They could also slander you in the newspaper and or television and or within the court itself, so you can have a claim based on this common law tort. The other option is the invasion of privacy. privacy laws of the United States and or Canada, as well as Australia and the UK, deal with severe differential legal concepts. One is an invasion of privacy, a tort based on common law, allowing an aggravated party, which would be you, to bring a lawsuit against the individual who unlawfully intrudes into their private affairs and or discloses their private information, publicizes them to a false light, or appropriates their name for personal gain. This happens every time you have a court hearing and they publish your name in the court record and then publish it publicly through CanLII or some other legal online system. And then you could actually go back to use one of our other claims and nail them for defamation of character, libel, and slander. One thing that should be noted with these legal torts that we're claiming here, you'll notice that they follow criminal claims at the same time. So we actually have common law tort, which is what we're dealing with today, and criminal running in parallel. But a lot of these claims can be used against government individuals when they behave inappropriately. Then we have a thing called malicious prosecution, another common law tort, which is an intentional tort like the tort of abuse of process, and the elements include intentionally and or maliciously insulting and or pursuing or causing to be ensued or pursued a legal action in either a civil or criminal case brought without probable cause and or dismisses in favor of the victim of the malicious prosecution. Now, many times what I tell people to do in a court hearing is always contact the other side and try to settle your differences and point out where they're behaving inappropriately and or contrary to the prescribed statute. Now, what that does, if they want to persist and keep on going with their court hearing, is they're now involved in malicious prosecution because you've told them where they're making their mistake, and there's a common law claim or a system where they say ignorance of the law is no excuse. However, they can't claim ignorance of the law is no excuse because you've now presented them with the evidence and or case law or statutory regulations which prove that they're operating outside their legal authority, and if they persist in doing it anyway, then go after them for malicious prosecution. Malicious prosecution in some jurisdictions denotes the wrongful intention of criminal proceedings, while the term malicious use of process denotes the wrongful and intentional of civil proceedings. Laws of the United States deal with several different legal concepts, as they do in other jurisdictions like Canada and or the UK and or Australia. So you can nail them both criminally and civilly depending on your specific application. Now we have medical malpractice. Medical malpractice is a legal situation, that cause of action that occurs when medical or healthcare professionals, through negligent act or omission, diverts from the standards of their profession, thereby causing injury and or death to the patient. This negligence might arise out of errors in diagnosis, treatment, aftercare, or health management. This situation would also be applicable to anybody that has taken the medical intervention known as COVID-19, because that has never been proven, it's never been isolated, and they were practicing medical procedures often done outside of a hospital or medical setting, and most times done without a trained professional, which is a contravention of the Regulated Health Professions Act in Ontario, and also various other acts depending on your location. As a result of this medical malpractice, they also did not disclose the dangers related to taking any sort of medical procedure, and as a result, the doctors and or hospitals could be held for medical malpractice. I have done additional videos which explain the problems with the COVID-19 vaccination process, which is not actually a vaccination, it's actually a gene therapy altering medical procedure. Additionally, when they force you to wear a mask or take a PCR test, again, that is not done by a prescribed medical professional, it is not done with full disclosure, and it is not done in a medical setting, Therefore, if your employer and or place of employment demands that you do this, ask them if they are going to accept liability for any damage that is caused to you now and or in the future in perpetuity. They will not give you that type of guarantee, and therefore you have lawful excuse to disobey the medical procedure. Canada is one of the only places where, under our Constitution, you cannot be forced to do a medical procedure against your will. And therefore anybody that has been terminated as a result of not undergoing the medical procedure in 2019 and or terminated as a result of any other protocol such as not wearing a mask can go after the employer and or company as a whole for medical malpractice. Now we have negligence. Negligence is a failure to exercise appropriate and or an ethical ruled care expected to be exercised amongst the specific circumstances. The area of tort of law known as negligence involves harm caused by failing to act or carelessness, possibly with extenuating circumstances. The core concept of negligence is that the people should exercise reasonable care in their actions by taking into account potential harm that they might foreseeably cause to other people and or property. Now there's gross negligence, which is when you really go over the line. However, local municipalities are doing this when they're imposing council tax and operating outside the legal framework, which they're obligated to know. Okay, so that should be a duty of care that they're expected to know, and also involving harm by failing to act in a form of carelessness in extenuating circumstances. So if you notify your local council, for example, that they're breaking the law and they persist in doing it anyway, then you have them on gross negligence because you told them of such situations. The same thing happens in Ontario when you deal with a local municipality who has no right or authority to regulate property standards bylaws and or push a bylaw through without the proper protocol being followed under the Municipal Act and or Building Code Act. When this happens, you now have a legal claim against the municipality, and specifically in this case the chief building official and or mayor of that corporation. Further, as a result of this action, no claims should ever be able to be made against you, and they have now committed gross negligence causing harm. In some cases they have seized vehicles and or destroyed property. You have every right as a property owner to defend your property and use reasonable force under the Trespass to Property Act of Ontario to prevent such actions from taking place. In the UK, you have a similar situation because the council tax does not apply to non-domestic property. In other words, council tax does not apply to private property. As such, you have every right to defend your property and or prevent the bailiffs or other fraudulent employees from stealing your motor vehicle. We can get further into negligence at another time. Then there's negligent infliction of emotional distress. This tort of negligence is inflicting emotional distress on somebody, which is basically causing you to stress out over some procedure which they have a legal duty to use reasonable care to avoid, causing emotional distress. Police officers on the side of the road that pull you over very often get you to do things and or admit things or say things because you're under emotional distress. You're under fear because you have no idea what that armed thug carrying a nightstick, pepper spray, a taser, and a gun may do to you. Therefore, anything that happens on the side of the road should be done and should be noted that it's done under threat and duress. If one fails in this duty and unreasonably causes emotional distress to another person, that person may be liable for monetary damages to the injured individual, which in this case is you. When the local council tax people are in their fraudulent Mickey Mouse clubhouse court, perpetrating itself to be a true court, and the legal person in there, the legal representative, states that they can commit you to prison, that is causing you emotional distress. your fear of being locked up for the next 6 months may cause you to say and or do things which you normally wouldn't do. For the record, a magistrate's court does not have the authority legally to imprison anybody, because that's only applicable in a criminal charge, and civil claims, which are cases of magistrate's court related to council tax, are exactly that, a civil claim, and as such they have no right to put you in prison. The same thing happens with the local municipalities in the province of Ontario, and in fact all across Canada, because everything you do with the municipality, unless you actually destroy property, would probably fall under a civil claim. Now, there's another thing here called strict liability. In criminal cases and in civil cases, strict liability is a standard of liability under which a person is legally responsible for the consequences flowing from an activity in the absence of a fault or criminal intent on the part of the defendant. So what this means is a party working for the government has some sort of a liability. It's a standard of liability which the person is legally responsible. Therefore, no council tax person can state that they're immune or that the government has sovereign immunity when you've notified them of their criminal activity and they continue to do it. That happens for every government agency, whether it's in Canada, Australia, New Zealand, UK, I don't care. They have a strict liability because they have to be publicly bonded in order to operate in public. So that proves that they have a liability, and their liability goes right through the roof. If they've operated outside the legal framework of the statute, you can then go after them in their private capacity, and their so-called alleged immunity goes out the window. Contrary to what the court will tell you, nobody has diplomatic immunity to turn around and harm another person intentionally, especially once you've notified them that they're doing so. If the judge tells you that, you can get that judge disbarred. He's not being fair and impartial. The same goes for the judge. If the judge operates outside his legal framework and tries to enforce some sort of a ruling which is not based on the statute, then the judge has no authority to do that. We call that ultra vires, and you can go after the judge in his private capacity. There is a protocol for doing that. Now, strict liability, again, the defendant possesses anything that intentionally dangerous as specified under the ultra-hazardous definition. The defendant is then strictly liable for any damages caused by such possession, no matter how careful the defendant is in safeguarding them. So this states right here that even the defendant has a strict liability. So if we bring this back to a government situation such as council tax or property standards issues, both parties are liable for their actions. Therefore, please ensure that you do everything in your power to operate within the statute and point out where their deficiencies are to the government and or municipal people. Therefore, you can nail them under strict liability. The next charge we have is called trespass to chattels. It's another tort whereby the infringing party has intentionally and in Australia negligently interfered with another person's lawful possession of chattel, which is movable personal property. Now you might call that a vehicle, because a vehicle is movable and it's personal property. The only thing that this wouldn't apply to is a house, because theoretically a house isn't movable. If you move it, you probably destroyed it. However, if you live in a mobile home, then that would be movable personal property. This interference can be any physical contact, okay, in a qualifiable way, or any disposition, whether by taking it, destroying it, or barring the owner access to it. Well, such cases would be applicable in the province of Ontario when the municipality comes along and thinks they can take things off your property. And or sometimes they will go to other lengths which are also illegal and even more a trespass. I won't get into that now because I want to give some counsels ideas. There's also called trespass to the person. Trespass to the person is historically involved 6 separate trespasses. threats, assault, battery, wounding somebody, mayhem, or maiming them, and or false imprisonment. Notice all these things that we dealt with earlier fall under the trespass to the person. This can also include, but is not limited to, causing somebody to think in a certain way, based on false statements. Now, through the evolution of common law in various jurisdictions and or codifications of common law torts. So if you wanted to look into that, you could. Now, when they tell you they're going to falsely imprison you, or that you may be charged for defending your property against an unlawful action, that is a trespass on the person. The local municipality in Ontario is guilty of that, as is every other council that's gone to magistrate's court where the legal advisor has stated that the person could be sentenced to committal to prison. This also would include people that have already been committed to prison by the Magistrates Court Act. And when I notified the Chancellor of the UK government of such infractions, he said that there was nothing he could do about it and washed his hands. That should give you a clue that there is no legal system left, at least in the UK and primarily in Canada, as well as Australia, France, Germany, and Belgium. Take that for what it's worth, people. Trespass to the person in most jurisdictions now broadly recognizes three separate trespasses to the person. Assault, which is any act of a nature as to excite an appropriation of battery. Battery, any intentional and or unpermitted contact with the plaintiff, could be the defendant, person, or anything attached to it and practically identified with it. And false imprisonment, or the unlawful obstruction or deprivation of freedom that restricts movement. So that's a pretty broad spectrum, and courts could be convicted of it on a number of occasions based on several court cases which I have reviewed. And then we have trespass to land, which is a common law tort or crime that is committed when an individual or the object of an individual intentionally and or negligently enters land of another without lawful excuse. Trespass to land is an actionable offense, and thus the party whose land is entered upon may sue even if no actual harm is done. There's a specific court case, R versus Lee, and Lee is spelled L-E, which is done by the Supreme Court of Canada, and it clearly states that the officers who trespassed on this person's land, and I think they bypassed a gate, went to the person's backyard and found out that the person had guns, I think they may have had drugs, and they had stolen property. All of this was inadmissible in the court of law because the police officers had no right to invade his privacy and or search his property. Therefore, any time that the local municipality in Canada, or at least in Ontario, trespasses on your property, trying to do something unlawfully, you have therefore a claim against them and or the court who does not follow superior court laws or superior court cases. And such a case happens frequently, at least in Ontario, with the local municipal governments, because they are not following the law, and in fact they disregard the law. The downside to this problem is, as a self-litigant, you're not an officer of the court, and the judge is generally dumbass and follows the rules and or protocols prescribed by the local municipal government employee called a solicitor. And the solicitor will state something to the court, and the court's not smart enough and doesn't do their due diligence and follows whatever the lawyer for the city tells them without even verifying the rules. However, if you notify the court of this mistake or notify the local municipality, they can't claim ignorance of the law, and therefore you can go after them in their private capacity. No one is above the law, and all are equal under the law. You'll remember that from my legal maxims presentation I done several weeks ago. Then there's also trespass to the land. We'll continue on. In some jurisdictions, this rule may also apply to entry upon public land, having restricted access. The court may order payment of damages and an injunction to remedy the tort. Well, if that can apply to the public, it can certainly apply to the private as well. If the judge fails to do their duty and fails to recognize a higher court claim, which I outlined earlier in R versus Lee, then you would have a claim against the presiding judge and as well as the municipality. They're supposed to know the law and the extent of the law to which they can operate, and they don't have immunity to do whatever the heck they want just because it suits them, contrary to their belief. The other claim that we might have here is a slip and fall. It's an injury known as a trip and fall, and the premise here is that the person is liable for the claim under a personal injury claim. And it's caused by a person slipping or tripping on the premises of another, as a result suffered an injury. This is a tort. A person who is injured by falling may be entitled to a monetary compensation for the injury from the owner or person in possession of the premises where the injury occurred. This means that if you slip and fall at the local post office or the school or other place of public access, you may be subject to a claim. You may be able to put a claim in for compensation. Now, the problem with this is you have to prove negligence on the part of the property owner. And if your property is fenced off, private property, no trespassing, and you enter at your own risk, well, that's your tough luck. You'll have to battle it out in court. However, if it's clear that there shouldn't be nobody there, then you've taken every reasonable step to make sure that this area is safe, then, you know, it's going to be who can prove what. The liability for slip and trip or slip and fall injuries may arise based upon the defendant's ownership of the premises where the injury occurred, their control of the premises, or both. So if you are involved in a slip and fall and you can't get a hold of the owner, however there's a manager taking care of, let's say, an apartment building, you may be able to go after that manager or that property maintenance department. For example, a store may be liable for a slip and fall injury that occurs inside of its premises, even though it rents those premises, because it has exclusive control of the interior of the rented property. The owner of the premises, the store's landlord, may have sole or shared liability for an injury that occurred outside of the store exclusive premises, such as the injury from a fall on the sidewalk or in the parking lot of a shopping mall. So please be sure that if you're going to make a claim, you make it to the correct party and do so according to the prescribed laws and statutes. And again, as I've said earlier in one of my earlier presentations, please be sure that you do it within the time frame under the liability, because there is a liability claim that can be made under a statute of limitations. If you're trying to claim something that happened generally more than 2 years ago, you will not have much luck because you're statute barred. The only exception to this, of course, is fraud, but that's not relevant to a slip and fall. The other claim that can come through is a wrongful death claim. This claim is against a person and can be held liable for death. The claim is generally brought in a civil action, usually by close relatives, and basically it falls under statute. Wrongful death causes the survivor to suffer loss or injury, and they're generally compensated for harm and the loss they've suffered after losing a loved one. Types of wrongful death claims can also arise out of medical malpractice. And it's usually a death resulting from negligence from a doctor or hospital. Or it may also be from a motor vehicle accident caused by another driver operating recklessly and or without undue care and attention on a roadway. And it may also be a defective vehicle due to a product liability because the brakes failed, because GM or some company decided to put in anti-lock brakes and the system fails. It may be a medical malpractice. Dangerous roadway claims resulting from death caused wholly or in part by the condition of the roadway. So if the roadway is in poor repair, that may be another claim. There's a number of situations, but it should be obvious now from going through these slides that most of these common law torts are also criminal charges, and so they run in parallel, as I've stated earlier. The tort damages explained is only a brief overview of some of the claims that could be made in connection with a case that may be ongoing or may be forthcoming, as was brought to you by Global Solutions. I hope you found this information helpful, and I look forward to providing you with an additional presentation relating to how to actually file a case in court. And I will try to cover both Ontario courts as well as the UK courts, because the protocol is slightly different. If you have any questions, I can be reached at the email address shown on the screen, and thank you. Have a good day.